Assalamualaikum and hi, my name is Nur Shafika Izati binti Azmi Rais with matrix number 066100, and I will start off this group presentation with my introduction on this topic. Malaysia was a country under a British colony until 1963. English law applied in sections 3 and 5 of the Civil Law Act 1956 aka CLA. Thus, these clauses made Malaysian courts obligated to follow English law, particularly in common law and norms of equity. In Section 3, the Malaysian court must either use or refer to the common law of England and norms of equity based on 3 different periods and jurisdictions. Note that not every aspect of English common law equity is recognized in Malaysia. Next, we'll be looking into commercial law under Section 5 of CLA 1956. Common law and equity are applied differently in commerce. Commercial law usually governs rights and duties. Merchant customs establish in statutes and judicial rulings and form this body of law. In Peninsular Malaysia, except in Penang and Malacca, uses English commercial law, but only until 7 April 1956 when the CLA took the effect. In Penang, Malacca, and East Malaysia always impose English law in commerce because there is no native law. Lastly, in Malaysia, land law. Malaysia interpret equity differently from England. We use the torrent system, which requires registration of land, titles, and interests. This system is administered by the National Land Code 1965, aka NLC, outlines these rules. Equity in land disputes may be problematic. Singapore, also a former British colony. The Second Charter of Justice in 1826 brought English equity into Singapore. Singapore courts apply English common law based on 2 key factors. A. The logic and reasoning behind the case precedents. B. The necessity to adapt to local circumstances and conditions. In Section 3 of the Application English Law Act, Chapter 7A, 1994, revised edition, states Common Law of England, including principles and rules of equity, so far as it was part of the law of Singapore, subject to modification and suitability to the circumstances of Singapore. Chapter 43, 1999, revised edition of the Singapore Civil Law Act, also allows the court to adopt both common law and equity principles, allows a claimant to seek both common law remedies, for example, damages, and equitable remedies, for example, injunctions and specific performance in the same court action. Singapore's common law also incorporated local jurisprudence. Introduction on equity aids the vigilant but not the indolent, aka delay defeats equity. This maxim applies to equitable claims that are not subject to a statute of limitation or other similar time limits, cannot be applied in circumstances where there is a delay. The existence of the unreasonable delay by the claimant and existence of conditions resulted to inequitable to raise the claim and necessary to establish the doctrine of laches, meaning innocent party may lose his right to equitable remedies for breach of contract if he delays or fails to bring in action, thus could confirm the other evidence that he has accepted the breach. The law generally imposes time limits on when a plaintiff may file a claim in court to treat the defendant fairly. If there is no time restriction specified, equity will preclude a claim from being brought to court if it has been delayed for too long.
I'm Washika Napawan Shantaraganan, and I will present about the application and cases in Malaysia. In the case of Machijang Skyway Sendirian Berhad and another against Lembaga Pembangunan Langkawi 2015, the first defendant was the owner of the Langkawi cable car system. On 28 August 2002, the defendant entered into a joint venture agreement, which is known as JVA, with plaintiff, resulting in a company being formed to manage and operate the cable car system. However, on 30 November 2002, the first defendant in breach of the JVA appointed the second defendant as the exclusive operator for the operation and management of the cable car system. A suit was filed on 10th of December 2002, but later was withdrawn as the parties had entered settlement negotiations, during which the first defendant wrote a letter dated 3rd January 2003 saying that it would make appropriate compensation for the plaintiff's losses and that if the parties were unable to settle on due course, plaintiff was at liberty to file a fresh suit to recover its losses. No settlement was eventually reached. On 20th November 2008, plaintiff issued fresh proceedings based on the thought of conspiracy, breach of JVA, and the thought of inducement of breach of contract. The defendants took out applications under O14A and O 33R2 seeking determination of whether the suit was barred by limitation pursuant to Section 2 of the Public Authorities Protection Act 1948 as against the first defendant and Section 6 as against the second defendant. In the Court of Appeal case of Embeng Berhad against Abdul Aziz Hassan and others, 2010, the respondents were all lawyers practicing with a law firm known as Mrs. Aziz Hassan and Co., who acted for the appellant in the preparation of loan documentation for a loan facility to be granted by the appellant for a loan sum of 800,000 to a borrower company known as MYT Builders Sendirian Berhad. The borrower's loan was to be secured by a third-party assignment which was to be executed by the third-party assigner Vice Corporation Sendirian Berhad, herein referred to as the assigner, who were Lot 465 Mukim Hulu Kinta Perak. Lot 465 was now one of the subdivisional portions of a larger plot of land known as Lot number 57,436 Mukim Hulu Kinta Perak, herein referred to as the master title. As a result, it was argued that the statutory limitation period for a tort-based claim should begin to run only after the damage was discovered. The Court of Appeal was not convinced. It was held that the Section 6, Subsection 1, Clause A of the Limitation Act is an absolute bar and that the courts lack the authority to extend the limitation period, which is that power is reserved for Parliament.
Hi, my name is Nurul Anyatira binti Muhammad Yusof and my matric number is 067682. Now let's move on to the case where the maxim of equity as the Vigilant and not the Indolent was applied in the case of Eller against Chiang Kietwa in Singapore. The issue arises in this case are whether the plaintiff claims it is defeated by any applicable defense, which is laches. The equitable defense of laches was summarized in Ching Wenhua against Gong Baheng, where the Court of Appeal emphasized that the basis for equitable intervention by the doctrine of laches is ultimately found in unconscionability, and that the inquiry should be approached in a broad manner as opposed to trying to fit the circumstances of each case with the confines of a preconceived formula derived from earlier case. In this case, the plaintiff has been aware of the shared issuance since February 15, 2016. However, the plaintiff did not notify the defendant of his intention to pursue his breach of trust claim until January 18, 2019, before filing the current suit on February 11, 2019. As a result, the delay in this case was slightly less than 3 years. This 3 years lapse, in the judge's opinion, was not long enough to cause serious prejudice to the defendant. In the circumstances, it was held that the plaintiff's delay is not unconscionable enough to bar him from equitable relief. As a result, the defense of laches fails. Next, referring to the case of Teng Wan Ki Seren against Tay Yap Ping and another, where in this case, the plaintiff Teng Wan Ki Seren claims that she established Seren Leather, a business that sells leather goods. She told her parents Go Ah Moy and Tay Sia Yong that the proceeds from Seren Leather would be used to buy an apartment from their family to live in. The defendant contends that Seren claim is time bar under Section 32 Clause 2 of the Limitation Act because her right of action arose around 1988. Seren claims that the exception in Section 22 Clause 1 Clause B of the Limitation Act applies to her claim because it is based on a resulting trust. However, in the present case, the essence of Seren claim is that there is a resulting trust. The court held that Seren claim is not subject to the limitation period of 6 years in Section 22 Clause 2. The final issue to be addressed is the applicable of the doctrine of laches. The defendant argued that Seren claim is barred by the doctrine of laches. Seren could have filed a lawsuit in 1988, 1991, or 2006, but she did not. She did not file a lawsuit until the end of 2019. The time difference is significant. As a result, the defense is prejudiced because father is mentally incapacitated. The father also unable to provide rebuttal evidence. Mother has died, relevant documents have been lost, and Seren will benefit from her own delay. Finally, because the judge does not believe Seren waited too long to file her claim, such prejudice can only be described as unfortunate. It is not the result of any undue delay or error on Seren's part. In conclusion, Seren claim is not barred by the Limitation Act or the doctrine of laches.
Hi everyone, my name is Nishanta Balakrishnan and my matrix number is 068705. Today I am going to explain about the exceptions to the maxim. First exception is where the law of limitation expressly applies. The second is where the law is applied by analogy. And third is when the law of limitation does not apply, but the cases are governed by ordinary rules of laches. In conclusion, the maxim delay defeats equity must not be applied with the blindfold that symbolizes justice. The facts of each case must be looked into. For delay to operate as a bar, it is essential that it should prejudice the defendants.